going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you guys are having a great day so far. All right, I've got two pro se clips, both out of Florida, both in front of Judge Clark. I actually think it was on the same docket. All right. Well, one guy does okay, the other one does absolutely terrible. Let's watch. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Mr. Davis, okay. This is Michael Ray Davis, case number 23 CF 359 and 445. And what are we here today for?
Motion to compel.
Sir?
A motion to compel, Your Honor.
In what case?
On my trafficking case.
Does the state have a copy of it? Did you send a copy to the state?
Yes, sir.
Okay. All right, Mr. Davis, what are you saying you don't have?
Your Honor, I'm asking for the audio recording of the control call that the officer wrote in his report that he turned in evidence. I'm asking for the search warrant application that's due to the case because the officer stated that in deposition that they executed a search warrant to this resident and ran into a CI that gave them information. So I'm entitled to the search warrant application because I was pulled inside the scope of a search warrant, Your Honor. I'm asking for the cab calls.
Mr. Sullivan?
Your Honor, in my
Mr. Davis was pulled over pursuant to a controlled buy operation. It was a traffic stop. He was seen throwing the baggage open in the back of the car and he was arrested. No, sir.
Your Honor, it all stemmed from in deposition. The officer stated that they executed a search warrant on 3121 Amanda Circle. In the process of them executing the search warrant, they ran into a confidential informant and he provided them information, and it's all inside the scope of the warrant.
So he's seeking a search warrant on somebody else's case. The state doesn't intend on applying.
Okay, Your Honor, but I'm asking for my cell phone information, pictures of the cell phone. I'm asking for the audio recording of the recorded conversation because in his arrest affidavit, the officer clearly stated that he turned the audio recording into the Bay County evidence custodian.
Mr. Sullivan?
Ms. Judge, we've litigated this before with Mr. Scott when he was on the case. I believe he could chime in. There was some conversation that was recorded. I believe this is the one where the officer in the next day or so was in some type of incident where the recorder was actually run over by the Bay County vehicle. That recording doesn't exist.
They don't have it. They don't have it. If they say they don't have it, there's nothing I can do.
I'm asking for the cell phone information, Your Honor. He clearly stated that all evidence was turned over. I'm arguing dispute, Your Honor. No phone call was ever made to me, Your Honor.
Whose cell phone? Yours?
My cell phone, the cell phone they used to call me, all that, Your Honor. All this was turned into evidence, and there's no history of a cell phone.
There is no cell phone information. There's no warrant that for the cell phone. There's no extraction. There's no cell phone information.
There's nothing I can order if they're saying they don't have it.
Right.
You understand, Mr. Davis, at any point in time that you can ask for an attorney, Mr. Scott will be appointed to represent you.
Yes, sir.
Okay. You're still requesting to represent yourself?
Yes, sir, because I'll be filing a motion, Your Honor, for a Richardson hearing on the Brady violation.
You need to file your motion then.
Yes, sir.
All right, we'll set it for, yes, sir.
Judge, I'm asking for the next motion date so that can get done, and I'm asking for a trial date. Mr. Davis actually filed a demand he filed almost a year ago. That was denied because this case has been going on for a while.
Let's set it for November the 22nd for a motion. You need to get it filed
Yes,
prior to
sir.
that date, and we'll set it for February 3rd at 8:30 for a trial, and we'll take up a trial management on that November date. Okay?
Appreciate for your time, Your Honor.
Yes, sir. Is that all you have, Mr. Scott?
All right, that's the guy that I said did okay. I mean, he saw something in his, I'm guessing, his charging report, or he said his deposition, where they were talking about a phone call where, yeah, phone call, phone records, and he's asking for that evidence. The state's saying they don't have them. If he had an attorney, the attorney would tell him how to follow up on that. Unfortunately, he doesn't have an attorney; he's representing himself. And if that, the phone records were what they used to pull him over, then I mean that is relevant. But if yeah, you know what? Let's just move on. When I start talking in circles, it's time to move on. All right. This is the pro se that absolutely butchers it. This is so bad to watch. It is cringe. And Judge Clark even feels bad for this guy and kind of holds his hand throughout this entire process. But get ready for some cringe pro se performance.
All right. Mr. Poyer, you're before the court today in case numbers 24 CF 2543 and 2544. You're representing yourself, is that correct?
Yes, sir.
Do you wish to continue to represent yourself?
Yes, sir.
You understand at any point in time you can ask an attorney if he appointed to represent you. Mr. Williams is available for appointment.
I understand.
All right, you filed some motions for today. Which ones do you want to take up at this time?
Bond.
The bond reduction?
Yes, sir.
All right, you may call your first witness.
Sir.
You may call your first witness.
First witness.
Yes, sir.
I got my girl out.
I mean, you don't have to call. You don't have to call. I mean, that's how you usually have a hearing. That.
Yeah, she's right here.
You want to call her?
She's right good more. She's right there.
All right, come on up, man. If you'll raise your right hand.
You solemnly swear the testimony about to give the truth, but the truth of God. Yes.
All right, you may inquire, sir.
Sir, pretty much, I just need to get home because.
Hold on, Mr. McCoy. You got a witness. You need to.
Oh, you told me to go?
I told you to ask her a question. You got to ask her questions if you want to. If she's your witness, you got to ask her questions.
Okay, what type of questions, Mr. Clark? I mean, as far as my bond, like.
Yes, sir. I mean, this is a hearing. If
right.
you don't have witnesses, that's fine. You don't have to call a witness. You can testify on your own behalf. You can make an argument.
Okay,
you're representing yourself.
I understand what you.
I know you're not trained, but I mean, you've seen hearings happen before. But I mean, it's up to you. I mean, you're representing yourself.
I understand pretty much. Okay, I need to ask her questions.
Mm-hmm. Well, if she's going to testify, you got to ask her questions. Right. Yes, sir. Now she doesn't have to testify. It's up to you.
She can testify. I'm gonna get her to testify, sir.
Okay, well, she's under oath. You can go ahead and ask her.
All right. Anyway.
You'll start by the first question. The only time I can help you is ask her name and let her put her name on the record. Then you can go forward.
All right. What's the name?
Sherelle Gilmore.
Okay.
So do you swear to tell the truth and all that?
I've already sworn her. The clerk, so she's under oath, so you can ask her questions.
Anyway, this is my fiance. So do you need me home, right?
Yes.
Okay, you need me that I'm the provider of the house.
Yes, definitely.
Kids need winter clothes.
Yes.
We have bills to pay that need to be paid. I'm the provider, so.
Yes.
So like what like.
I'm gonna be able to provide transportation for you, but I need you home.
Definitely need me home, sir. So.
Okay.
And as of right now, sir, I'm gonna be honest, from the last case and all this time, we don't have any money, and money is an issue right now because I have been dealing with this old case that just got thrown out after all these years, whatever, but I can't afford bond right now, so I'm needing it to be low as possible, or maybe even or if that's even possible, so I can get out and provide for my kids, like I said. So whatever I need to do, whatever that can be done,
okay.
Please make that happen today, sir. That's all I'm asking.
All right. Is that all the questions you have for your witness?
I mean, it's pretty much, yeah, I need to get home. Yeah, I'm the provider of the house, Your Honor. You know, kids need winter clothes, bills need to be paid. I need to be there to do it. I can't do it from this side.
Okay. The state have any questions for the witness?
No, Your Honor.
All right, ma'am, you can have a seat. He's got two informations filed. One's a third-degree felony, fleeing or attempting to elude law enforcement. That's in case number 2543 CF. And then in 24 CF 2540 theft is another information's been filed. Is that correct? Yes. Fleeing or attempting to elude high-speed reckless. That's a second-degree felony, unregistered motor vehicle, unassigned license plate. What's the state's position?
Your Honor, the state's position is that he is entitled to a reasonable bond, and but in considering that motion, noting that these high-speed reckless pursuits took place lots of resident players, that there was a lot of risk to the public that and fleeing and attempting to elude. One of the reasons that we have bond is to make sure that they show up to court. Fleeing is the biggest indication of a flight risk that there is. So the state would agree that he is entitled to a reasonable bond, but that bond would still be enough to compel Mr. McCoy to return to court.
Now, what's the bond set on the 2533?
43.
2543. I wonder if did the judge find there was no probable cause for that? $1.
The charge had been amended since then.
Okay. All right, I'll leave that bond as it is. On case number 2425 CF, I'll reduce the, I guess it's $100,000 on the fleeing and attempting to elude.
That's correct, Your Honor.
I'll reduce it to $25,000. On the no vehicle registration, I'll set it at $500. Tag attached, not assigned, $500, and reckless driving, $500. That's the best I can do today, sir. That's a total of 25,000 plus 26. Was it $26,500 and $501? What else?
Okay, we got that far about the discovery.
Okay, what discovery are you asking for that you don't have?
Well, pretty much the videos, to show that it was a clear mistake. Because
well, I mean, I don't know. You don't have to tell me what they showed, but
the only reason I feel like that's so important right now, Mr. Clark, and my everything should be based off of that, because the SID officer clearly mistaked me as a cartel member.
Okay.
He thought I was a cartel member when they bum rushed the car like that. And the only reason I ran because I was in fear for my life.
Okay, well,
so I just want to state this for the record, Mr. Clark. I ran for my life because I had 15 cars trying to box me in with no lights on in regular vehicles.
Okay.
They thought I was a cartel member, so they clearly hit the wrong person.
Do you have what? You don't understand.
I'm just requesting these videos because it's going to clearly show that.
Yeah, I'm going to see what the state's position is.
Your Honor, as per, I know he requested the Stefco gas videos. It is my understanding that was never pulled and that gets deleted every 30 days from our understanding. Additionally, the dash cam FHP, I have that video, but I don't have a way to.
Since he's pro se, I'm going to ask the state to figure out some way to get it to him. And I'm not going to ask the state to come show it to you. I don't know, because usually what happens is that the defense provides a tape. Is that correct?
There is a way, Your Honor. We can provide a disc to the jail. There's classifications all.
I would appreciate it. If y'all could do that. How long would it take you to do that?
We can have the disc run today. It'll probably be the beginning of next week.
All right. If I'll grant that motion to compel and ask the state to do that, to get that video out.
They'll tell me exactly what videos it is going to bring, because the body cam also after the chase stop.
Go ahead, Mr. What do you have on that?
The only video that I have so far is the FHP dash cam. I've sent out requests for anything from Bay County, but all I have so far is FHP dash cam.
Okay. All right. So
is going to prove it.
Well, I mean, if they can't, if they don't have it, they can't make them. But I'm going to ask to continue to try to find out what you can get and to provide that to Mr. McCoy. Okay.
Okay. Can I call up my witness one more time about the video?
No, I mean, I've already told them, I've already granted your motion.
I'm talking about the store, from the store.
Oh, I mean, the video for the store?
Yeah, because that's gonna prove my point about my innocence. I really need that.
Well, you need to go get that yourself.
How can I?
I got no idea. That's not the state's position. The state had, do you have that?
What you got,
No,
Miss?
Your Honor, and we requested, Mr. McCoy had brought this up, so I had requested to see if they had collected it, and I had not, and I was told that it wasn't collected, and they get the store deletes it every 30 days.
Okay.
to rewrite.
So that, I mean, they've said they don't have it. So I mean, if you want to do your own.
All right, here's the thing. It's not the state's job to prove that you're innocent. It's not. And it's not your job to prove that you're innocent. It's the state's job to prove that you committed whatever you're charged with. So you don't need to produce any evidence. I understand that you might think that there's could be this footage out there that's going to show that I didn't do what they're saying I did. That's fine. You can try to get that. You can ask the store owner for that video. That's what an attorney's for. The attorney would get that video for you if he thought it was relevant. You don't have an attorney. You're asking to subpoena something, or you're asking the state to give you evidence that they're not going to go out of their way to get. They might have enough evidence to already prove the case. Why would they go find evidence that they don't need? Oh, all right. Well, that's it. I'm going to let the rest of this video play out. Thank you guys for watching. If you haven't done it already, please hit the like button. Until next time, bye.
Own investigation and see if they can get it. That's up to you, but the state's already indicated they don't have it.
Okay, if they can't produce that, that's like, because I put in.
That doesn't, if they can't produce it, that doesn't mean anything. I mean, that's from a storefront.
But I requested that like my second week in jail. So I figured that's
I don't know that they have, I don't even know if they had a right that you could have a right to go tell them what to do. I mean,
I put in a subpoena through the court, like, I filed a subpoena.
Well, I mean, I don't know that you can direct the state, but that's something you can litigate it later. But I've already granted your motion. They're going to get you what they got. Okay. All right, November 22nd at 9:00 for a review here and see what else we got. All right, Mr. Williams, that'll conclude everything. Thank you, sir.
Thank you, Your Honor. You have a good afternoon.
You too.